Hello, I'm Sarah Gillis, founder and chief dreamweaver here at Aspire Australia. Thanks for joining us for this 6-part video series on how to nominate a worker for a subclass 482 visa. In video 5, we're looking at pulling it all together and showing you how to submit a decision-ready application. Processing times at the Department of Immigration can be up to several months. So when the department case officer opens your file, you want them to be able to make a decision straight away. Ensuring that you have given all the relevant information and documentation will make this happen. So let's look at what you need to do. First, you need to have the funds available. Lodging the application will cost $330 plus the Department of Immigration's credit card surcharge. In addition to the lodgement fee, however, you will also be paying the SAF levy. This is the common name for the National Training Contribution Charge. This is a new levy payable by all companies nominating for the 482 visa. The figure is based on your turnover. If your business's turnover is less than $10 million, you'll pay $1,200 for each year you wish to nominate your worker. So, for example, if you want to nominate an accountant for 4 years, you will be paying $1,200 times 4 equals $4,800. For occupations on the STSOL, as you know, the maximum period is 2 years, so you would be paying $1,200 times 2 equals $2,400. It's very important to keep this levy in mind because A, it is payable at the time of lodgement of the nomination, and B, there are very limited circumstances in which the levy will be refunded. If the nomination is refused for any reason, or if you decide to withdraw the nomination, the levy will not be refunded. The only circumstances in which the levy will be refunded are these. If your applicant has the visa approved, but they do not start work with you, then you may seek a refund of the levy. If the visa application is refused on health or character grounds, you may also seek a refund of the levy. Or finally, if the visa holder does work with you, but leaves within the first 12 months, then you will be refunded the balance of the levy for any further years. It's also worth noting here that if you are transferring a nomination for an existing 482 visa holder, you will only need to pay the levy for the first year. So even if that visa holder has 3 years left on their visa, you need only pay the levy for 1 year. The employer must pay the SAF levy and the Department of Home Affairs fee. This cannot be passed on to the nominee or the visa applicant. Every application should have sufficient supporting material attached at the time of application so the case officer can make an immediate decision. In this video series, we're concentrating on the nomination application. Before you can lodge a nomination, you must have a sponsorship application lodged and approved. To lodge a sponsorship, you must show the formal structure of the business, for example, the ASIC, the ABN, any trust details. You must also show the financial viability of the business through provision of financial statements or statement from your accountant. In relation to the nomination, the first element you must address is the operations of the business. Remember, the Department of Home Affairs case officer knows nothing about your business. Let them know by providing details from your website, corporate material, or other information. Provide an organisation chart. Provide evidence that the business is currently operating by way of recent supply invoices. Labour market testing we've covered in a previous video. Full detailed evidence of the labour market testing must be provided at the time of application. An employment contract is a requirement for the nomination. It must be compliant with all Australian industrial laws and should incorporate the National Employment Standards. The employment contract should indicate the base salary to be paid, any other terms and conditions, and should provide the full job description. It must be signed by both the company and the nominee, and it must be dated after the end of the labour market testing has been completed. Finally, the company should provide a statement as to why the position is a genuine position available within the business. Your visa nominee will lodge his or her application, including evidence of their skills, as we discussed in a previous video, evidence of their English language ability. They will provide police certificates and may need to do medical examinations. And if their occupation is on the STSOL, they will provide a personal statement about their genuine temporary entry to Australia. Each of these documents will be uploaded to the relevant application online through the IMI portal. In summary, we believe in keeping it simple. Address each and every criteria, but remember that the case officer knows nothing about your business or the position, so make it clear and make it simple for them to understand. All documentation should be addressing the criteria and there should be nothing superfluous. Be ready with your credit card to pay the fee and the SAF levy, remembering that neither will be refundable. If you're a busy business owner or a harried HR manager, we know that you've got challenges with the 482 system. Don't worry, we've got you covered. As a reward for joining us on this 6-part video series, we'd love to offer you a free 20-minute discovery call with me. The link is in the email that you've received, and just click on the link to book your time. I look forward to speaking to you soon. I'll see you next time on the final video in this series. Bye for now.